Hi, my name is Benjamin Davis, and this presentation will be focusing on the Commerce Clause and how it relates to the Affordable Care Act. So just for some brief overview and information, this is a recent issue that has been contested by President Trump and the Republican Party. In the past, the Republican Party has challenged two provisions that the United States Supreme Court has agreed to hear. In the case, National Federation of Independent Business versus Sebelius. So this is a complex case with a lot of moving parts, so we're just going to focus basically on the Commerce Clause and how it affects the Affordable Care Act and if it allows Congress to put in a universal health care plan. So, as stated from the United States Constitution, the Commerce Clause gives the Congress the right to regulate commerce with foreign nations and among the several states and with Indian tribes. Throughout the years, the interpretation of the Commerce Clause has changed, so we're going to look at a few precedent cases just to see the bounds of the Commerce Clause and how it affects business law. So this presentation is going to focus on the Commerce Clause, but more specifically its interpretation as it relates to the Affordable Care Act and the healthcare field. The two sides of this case are obviously Democrats and Republicans. This is the first case, and two provisions are going to be challenged. Democrats assert that the Commerce Clause is sufficient for the Affordable Care Act and its enactment, as seen from this quote. The health industry is, of course, an interstate business. There's a continuous flow of health insurance payments, health insurance reimbursements, drugs, doctors, patients, donations to hospitals, research money, etc., across state boundaries. Congress's regulatory power under the Commerce Clause is not limited to direct control of interstate transaction. It includes the regulation of activities that affect an interstate industry, with activities including inactivity. So the petitioners in this case have two main arguments. One for the individual mandate, which requires individuals to purchase a health insurance policy providing a minimal level of coverage. The Republicans believe that the Commerce Clause doesn't extend here and shouldn't be able to require people to buy something from the government. And also the Medicare expansion, but that's not what we're going to be focusing on in this particular presentation. So the issue arises: is the Supreme Court's use of the Commerce Clause correct when dealing with the Affordable Care Act? So here are a few rules that we're going to be discussing throughout our analysis. Number one, the Patient Protection and Affordable Care Act. Article 1, Section 8 of the United States Constitution, which has a few additional clauses in addition to the Commerce Clause that we will be examining. The precedent cases Wickard versus Filburn, United States versus Lopez, and United States versus Morrison. The creation of the United States Constitution granted the federal government enumerated powers, which gives them the right to assert things like the Commerce Clause to acts. But as previously stated, the interpretation has changed. So as a quote from the National Library of Medicine, we can kind of see the questionability and the complex nature of the Commerce Clause. So it states, the constitutional legislation concerning healthcare reform has brought increased attention to the complex nature of the Commerce Clause and its relationship to the public's health. So to examine a few precedent cases, Wickard versus Filburn was the most far-reaching decision in the Supreme Court concerning the Commerce Clause. It stated that intrastate commerce can affect interstate commerce. The case United States versus Lopez is perhaps the most significant one in this particular case because it grants that Congress has the right to regulate commerce in three different areas. So number one, the channels of interstate commerce, persons or things in interstate commerce, and those activities that substantially affect interstate commerce. Now, in my opinion, the second and third areas seem to be fair in this case. Persons or things, interstate commerce, people are obviously being dealt with a healthcare plan, and the activities that substantially affect interstate commerce, for example, medicine trade across state lines, which has to do with healthcare. However, though I think that the Commerce Clause is enough to assert the Affordable Care Act, and a few other clauses can be asserted to kind of state additional evidence. So in Article 1, Section 8 of the U.S. Constitution, the Tax and Spending Clause states that Congress may lay and collect taxes, duties, imposts, excises to pay the debts and provide for the common defense and general welfare of the United States. Now, obviously, welfare has to do with health insurance, so I believe that since people are involved in this and their welfare, that under the Taxing and Spending Clause, Congress should be allowed to penalize people who do not buy health insurance. In addition, the necessary and proper clause has been stated in this case by the Supreme Court, and they stated that we have long read this provision to give Congress great latitude in exercising its powers. Therefore, Congress can assert its great power, as stated here, under the necessary and proper clause. So in this case, justices that voted for the Affordable Care Act kind of disagreed on the reasoning behind it, which means this is a plurality decision. I personally side with Justice Ginsburg in her concurring opinion. The Commerce Clause is enough for Congress to enact the Affordable Care Act, but I also do agree with Chief Justice John Roberts in his assertion that the Necessary and Proper Clause and the Tax and Spending Clause give the right to establish this Affordable Care Act. In the future, I think we just need more consistency. As you can see from those precedent cases, and there's more than that, that Congress throughout different areas of history has enacted this, either more strict or more lenient, but this future of the Commerce Clause is really, we're not sure quite what's going to happen, just because this was a plurality decision, so we don't know going forward how Congress is going to be allowed to act under the Commerce Clause. But like I previously stated, I believe that because of the Commerce Clause, Congress should have the right to assert this Affordable Care Act. And with that, that concludes my presentation. Thank you for watching.